That brings us to the highlight of the evening. So our speaker tonight has been here before. He's actually a Silicon Valley executive for several years here, a high-powered executive. In fact, I'm surprised, I'm amazed, rather, at the time and the effort that he has to spare to come and do things like this. So we're actually very privileged to have Gene Hoffman from Calguns come and speak to us tonight, and I hope we'll ask you to join me in welcoming him. And Gene, take it away.
I will warn everyone I'm a little bit under the weather, but that probably means that you'll actually be able to hear me. One sec. Great. So just a little preliminary comment. Some of you know who I am. Calguns gets thrown around. There's actually a couple of different organizations that are intimately related. Calguns.net is an excellent resource, an online forum for California gun owners. Calguns Foundation came out of Calguns.net, and we share some of the same folks. But we are the 501c3, the nonprofit that does legal defense and legal offense. We're also working with both CalFFL and the Firearms Policy Coalition. One of the things we can't do as much is actually lobby, though obviously we're involved in bills a bit. But those other organizations work with us very tightly, and obviously we're very close to the Second Amendment Foundation. You've seen Alan Gottlieb here before. I had the honor of being asked to become a board member of SAF, so I'm here in multiple hats in some senses. So it's an interesting time out there. We have this little thing called Newtown, and everything changed. So the good news is that federal gun control is dead. You're going to continue to hear Senator Kerry and others who don't understand the situation talk about it. But when there was not 60 votes for gun control, in fact there were more votes for carry reciprocity than there were for federal gun control, you know where things sit. The interesting thing, though, is it means the fight is going to be in the states, and one of those states is going to be here. But before I spend a lot of time on California, I want to give you a little more hope than what it looks like out there. Governor Cuomo in New York has seen his approval ratings fall through the floor after passing a draconian set of gun control. So even in New York State, there's been significant political backlash. Also in Colorado, there was a large capacity, or pardon me, a normal capacity magazine ban passed. 3 state legislators are now facing actual certified recalls. So there's going to be real hell to pay for a lot of folks who thought they could pass gun control in the wake of Newtown. The other piece of this is, in the same way that you did not see a lot of things move very quickly in California, even though we are facing a deluge of bad bills, you should not assume that all 47 are going to get there. In fact, at this point, we're down to about 27, and I expect to see more of those flies drop. Weird things protect us, and I'll talk about that more, but things like prison overcrowding in California causes a lot of these bills to not be able to create more felons and misdemeanants, and by the way, they want us to be those felons and misdemeanants. But this did have an impact on the courts, because where we're going to win this and where we're going to make California tolerable is in the federal courts. Kerry, we'll talk about that in extensive detail in just a second. There are a tremendous number of important decisions at the courts of appeals around the U.S. that have been held. Basically, we're not getting decisions in the kind of scale that you would expect from a time perspective. And a lot of that is the political backlash of they know we're right, and they're worried about the political outcomes of going to their country club and saying they voted for the right to carry. Okay? So it has delayed things some, but when you actually back up the Supreme Court, and I'll talk about this in a second, we've always said that we thought carry would either be just yesterday or the same time next year, and we're still on track potentially for the same time next year. So some of you are aware, but there is a nationwide strategy to bring the right to carry into something that looks somewhat constitutional. There are only now about 7 states and the District of Columbia that make it impossible or hard to get a carry license, or won't otherwise let you just carry, like Vermont or Alaska. We filed suits in New York, Maryland, New Jersey, Illinois, California, quite a few others. There's good news and there's bad news here. We lost in New York. We asked the Supreme Court to review that at the same time we had just won in Illinois. and the Supreme Court did not. Now that was quickly after Newtown. It's quite possible that they knew about the rest of the cases that are out there. The other piece of this is that the Illinois situation is very interesting. The Seventh Circuit Court of Appeals, some of the same judges who said that the Second Amendment wasn't incorporated in McDonald, ruled that, well, if you read McDonald and Heller, of course you have the right to carry, and that Illinois' entire and total ban on carry couldn't possibly work. They also commented about the New York decision and said that they didn't believe that that was a constitutional analysis that was valid, so they thought that that was wrong too, New York being a may-issue state, and like Illinois being a no-issue, no-carry state. Out of that has become a compromise bill. Illinois' carrying licensing structure looks like California, but shall issue. So it's relatively expensive, but it is actually a shall issue license. It has been passed by both parts of the Illinois state legislature. The Attorney General of Illinois has asked the Supreme Court for 2 extensions to file for her appeal of the loss. Her current issue is that she wants to give the governor enough time to think about it. The issue is, though, that the governor is facing a veto-proof majority. It's pretty hard to understand Illinois politics until you figure out there aren't a lot of representatives from Chicago. The rest of Illinois is exactly like you'd expect a central or western state to be. And so actually 2/3 of both houses would likely overrule his veto. However, if he were to veto the bill, the federal court's decision would go into effect and basically you'd be able to carry with only a FOID card in Illinois. So the anti-gun Illinois legislatures from upstate are facing a rock and a hard place. It's also not clear that even if the Attorney General of Illinois appeals that case to the Supreme Court, that the Supreme Court would take that one. Because frankly, it's probably a correct decision. And the Supreme Court is not usually in the business of taking a correct decision to clarify the law. That leaves a host of other cases. Currently, we won in the district court in Maryland, and so for a little while there, Maryland's may issue law was struck down as being unconstitutional. The Court of Appeals in the Fourth Circuit overturned that, and that is now being appealed to the Supreme Court, and there's quite a few cases in front of the Supreme Court. Additionally, New Jersey is waiting for the Court of Appeals decision, and here in California, we're waiting for the Court of Appeals decision in both Richards versus County of Yolo and Peru versus San Diego County. Those cases, the oral argument went exceedingly well. It was 2 weeks before Newtown. Normally, you would expect a decision in those cases in about 4 months. That would have been April. It is now June, heading toward July. There is an interesting wrinkle. You often hear us talk about we hate to see people try to bring federal litigation without knowing what they're doing, and the chief culprit in that case is a fellow named Gary Gorski. If those of you will remember the Silviera case where the assault weapons ban was upheld, but at least retired police officers couldn't keep them, that was what he considered as a win. He had filed a couple cases against Kerry in Sacramento County, and unfortunately his cases are earlier. So the court actually has a relatively difficult time reaching, in some senses, the good cases from ourselves and the NRA and Paul Clement and Alan Gura because Mr. Gorski's case is sitting out there. So it complicates the situation a bit. But there's reason to believe that even if we were to lose the rest of these cases at the courts of appeals, that they would conflict with the Illinois case and would be taken by the Supreme Court as early as next term. On top of that, there's some additional cases, and I will talk about this county specifically. The Calguns Foundation runs what we call the Carry License Sunshine Initiative. Even if we get the right to carry correctly interpreted, that you get a license to carry no matter what when you apply, the application process and the way that a lot of the sheriffs actually run those processes are actually unlawful under state law as they stand. And so we'll talk a little bit more about that, but we're spending a lot of time making sure that those counties are already cleaned up, even if they're not shall issue. So from that perspective, we're out there making sure that as carry comes from, if you will, on high, we'll actually be able to have sheriffs who will do the process correctly and issue once they're told by courts that they have to. Here in Santa Clara County, the Calguns Foundation is already suing the sheriff. That case is being held basically for the outcome in Richards and Peruta. So the cases to watch are the cases of the Ninth Circuit Court of Appeals. Even if we win or lose, it is likely a sexy enough topic that it will go en banc in California. So expect us to have yet another cycle even here before we go up. These are extremely important, and one of the important things, the reason Kerry is so stressed, it's both the obvious, which is this is the way that you get to exercise the right in the most risky environment you have out there. You know, 1/3 of violent crimes happen at home. That means 2/3 don't. So for all of you, our members, the people who matter, we want to make sure that you actually have a real right to carry. But the other reason we think this is extremely important is what you see in states that go shall issue is that something approaching 5 or 6% of the population will actually go out and get a permit. Those numbers really matter. When you have people who have a license, who actually carry a firearm day to day, especially when you put these firearms in these purses, you're going to change the politics of this matter, even in places like New York, Massachusetts, Chicago, here. How big is your magazine? It's become the most interesting conversation out there. LA City has banned the possession of previously possessed pre-2000 magazines. So if you have a 15-round magazine you've had since 1995 in LA, that's now a misdemeanor under the LA City law. A warning for those of you with carry licenses, be careful, possession is what they're banning. You heard a little bit about the San Francisco city attorney, and important to note it's the city attorney, it's not a criminal action, has gone after out-of-state vendors of magazine repair parts kits. Of course, selling a magazine repair parts kit is completely and totally legal. It's so legal that there's a bill in front of the California legislature to make it illegal. So as you can imagine, we consider this to be a pretty frivolous suit. You can expect that Calguns Foundation is heavily involved in, shall we say, dispensing with that lawsuit. The other piece is that legislatively there are 2 bills. There's the bill I just told you about and another bill to actually ban the possession of magazines holding more than 10 rounds, period, even if you had to grandfather. You'll hear me talk a little bit more about the politics of these bills. I don't think you can assume many of these are going to pass. And so from that perspective, we are in a little bit of a wait and see to see what the environment actually looks like come October or November after the governor has gotten these bills. But understand that magazines are very important. And I would harken back to Colorado. The 10th Circuit is actually a relatively gun-friendly place if you think about Colorado and Idaho and those sorts of things. We're actually pretty excited in coordinating with Mr. Capel in his challenge to their 15-plus magazine ban there. We believe that if the 10th Circuit can make the right decision and show that magazines holding more than 10 or 15 rounds are common and in common use, that will be very important, because the key to understanding how the federal courts work, if you will, is that to get the Supreme Court to look at issues, it's best to have one court of appeals go one way and one court of appeals go the other way. In many ways, it does suck to be in California because we're going to be the ones who lose. But if you've got a 10th Circuit opinion that says that these things are protected and a 9th Circuit opinion that says they aren't, that's a quick way to go back to 1 First Street, which is the Supreme Court in D.C. There, as I said, are quite a few additional bans proposed. San Francisco's thinking about a ban. There are some actual state law preemption problems with that, especially around carry licenses. It's not clear that the cities have the power to prohibit the possession of magazines, especially where gun stores can still get large capacity magazine permits and sell them to at least law enforcement. So, there are a lot of problems with this. You're going to see us put a lot of effort on solving this. We think that as an original matter, that the British banned the import of firearms to the colonies, and the Second Amendment was passed chiefly to enable the stopping of importation, stopping a government from stopping importation, I should say. So you can expect us to take a very direct challenge of this very shortly. Your semi-auto rifle is evil. Did you get the message? As much as this has been the major conversation, I would tell you I spend a lot of time with CBS and PBS and all the others, and it is shocking to them how popular the AR-15 is. And you're starting to see, in fact, in the major media, a begrudging acceptance that the AR-15 may be the most common firearm in America. The fact that you're seeing states like New York and Connecticut overreach on these issues, and that you're seeing other things like Illinois trying to expand their already existing assault weapons bills, you're going to hear me say the word overreach a couple times tonight. These are great ways for us to start laying the court requirements to make sure that the obvious statement that the most popular rifle in America certainly is protected by the Second Amendment actually is. A sleeper case that not a lot of people know about is called Wilson versus Cook County. Cook County, Chicago's county, bans just almost exactly like California, the assault weapons supposedly by features. This is in Illinois State Court, and the Illinois State Courts are actually, again, somewhat reflective, like the legislature is, of being relatively pro-gun. So we actually may get a state court decision protecting potentially both large capacity magazines and the AR-15 there. You will also expect to see New Jersey, New York, and Connecticut all have cases on this. We already have quite a few cases filed, but as I talk about the California legislation, we're going to wait until the fall to pursue because we want to understand what the actual state of play actually is. The bill you should pay attention to is SB 374 Steinberg. It is registration and a future ban of all semi-automatic rifles. All. Your 1022, your carbine, all. Okay? Now, this is such an overreach that we're talking about, a major portion of the entirety of the modern arms market. So on the one hand, it is a briar patch. In some ways, please throw us into it. The other thing I tell you is this bill is so much more overreaching that it's likely to make Senator Yee's bill be a sidelight and not go anywhere. It's just the bullet button specific bill. You'll hear Steinberg say, darn those people for their loopholes, and by the way, the loophole is owning firearms. But because the governor owns some of these semi-automatic rifles himself, it's not exactly clear he'll sign it. And in fact, that's what you're going to see in almost all of these bills, is that especially where there are other constitutional problems with these bills, the Brown administration doesn't want to put up with them. Magazine bans require confiscation. You're talking about turning a whole lot of people into criminals that were not criminals before. They don't have the dollars and they don't have the ability to take the budget back out of balance on these sorts of issues. But when you are thinking about what matters, and I'll talk more about the bills in a second, it's going to be Steinberg's bill, the ammo purchase restriction bills, and the magazine parts kit bills that are the ones that have legs. I throw up that red because if you go to calguns.net, that's what you'll see. Calgunfight.com, you can see the poster right here. You will see what you need to do when and where from all of those. I suggest going to both. The ammo purchase permit is a real problem. I mean, basically, it will practically ban the import of ammunition over mail order. I don't expect many gun stores to allow you to ship mail order ammo to them to transfer it. It'd be like asking Barnes & Noble's local location to let you ship Amazon books to it. Not going to happen. The other piece here is the normal magazine ban. Again, there are additional major issues with this, and if you ever want to watch how the governor communicates to the legislature what he does and doesn't like, watch the Finance Committee responses to these bills. So I think you all will recall that there was a 50-cent a round ammo tax. And of course, the Finance Committee had to admit that it would generate revenue, but it was a, quote, really bad idea, unquote. Okay, and the reason it's a really bad idea is because they were trying to signal that the government would veto it. Okay, so remember, as much as we have a 2/3 supermajority and they're all Democrats, they're not all the same Democrats. The other piece here is people would ask me the question, well, 2/3 majority, can't they override Brown's veto? You will find that there are a lot of Democrats in very purple places that will not want to be on such a hot potato at that sort of situation. So it's not clear at all that there are veto-proof majorities for any of this stuff. So the key is to watch what makes it down to the wire. Already we lost a lot of bills in the House crosses. You will see most bills die in the other House. You generally don't want to, if you're a senator, kill another senator's bill. You'd rather kill some assemblyman's bill. When we want that pressure, you will hear from us, the NRA. Please call, please write, please keep calling, call again. It is the Lord's work to call and keep them busy. And look, we are teaching another generation of that this is a third rail even in California, and it hurts. Okay? okay? The only way it hurts is for you to deluge them on this issue. You would rather convince every one of these legislators that they should be working on something that has some graft to it instead of some pain. The big piece will be which ones of these Mr. Brown will actually sign. And if you look back, Governor Brown has been relatively friendly. The worst thing you can say is that he allowed the registration of long arms bill to go through. His logic on that was all we were doing was changing the database, and that was it. So it was small, cheap, and not too serious. But everything else, including fixing the ammunition import bill, was vetoed. So, the Supreme Court did not take the New York case, but it was the first serious carry case to come to them, and it was before the Seventh Circuit had gotten out of the en banc scenario for their case. But there are more than just carry cases coming. There is a case from Maryland where a young West Pointer got in a fist fight and had a misdemeanor for which he paid $100 and never did anything wrong again. But the misdemeanors at the time in Maryland didn't have a cap on how long you could have been thrown in jail. So the ATF takes the position that he is dispossessed for life. Believe it or not, the courts agreed, and that is now being appealed to the Supreme Court. That and, if you'll recall, DC had a single FFL for a little while. So if you were living in the District of Columbia, you had to go to one FFL to transfer a firearm in because, of course, you can't buy a handgun out of state under current federal law. Well, DC was sued when that FFL lost his lease. So DC then opened the police station to the FFL and gave him a $1 a month rent to make sure there was an FFL in the District of Columbia. How mighty have they fallen. But the SAF has sued the District of Columbia and basically has said that it is unconstitutional to allow American citizens to buy long arms out of state, but not handguns out of state. Because, of course, if you can comply with all the restrictions necessary to buy a long arm, why can't you comply with all the restrictions to buy a handgun? Interestingly, the Washington, D.C. metropolitan entity actually amended their laws to say that if federal law would allow it, they didn't have a problem with it. D.C. is getting tired of being beat up. It's quite fun that way. Virginia looked at their own law and actually argued in an oral argument in the Court of Appeals that the law didn't say what it meant, that you could buy a handgun out of state and they wouldn't enforce it. Of course, it doesn't say that, but hey, details. Believe it or not, the case was lost because they claimed that consumers didn't have the right to sue about what dealers were restricted in doing. Of course, that's not the case in any other constitutional right, so this too is on appeal to the Supreme Court. So there are quite a few different types of cases that are under submission. The way the Supreme Court works is they're on summer vacation now. They hand down the last big blockbusters on the last day, and then they disappear. Wish Mr. Clarence Thomas luck that he doesn't eat too many cheeseburgers or drive the bus the wrong way. They will do nothing until what's called a long conference in early September, at which they'll go through all of the petitions that have stacked up over the last couple weeks and then all summer long. So, for example, when you hear that Illinois is stalling, it doesn't actually matter. They wouldn't have looked at the Illinois cert petition until September-ish. So that means that as the summer progresses and as these cases are decided at the various courts of appeals, and by the way, a side note, I'm only touching on some. The amount of defense and offense being played right now by all of the organizations is astounding. If I were to sit here and tell you all of the cases we currently have pending or moving somewhere, I would spend all night just on that. Now, to the extent you guys have questions there, feel free to ask, but understand how rich and thick the situation is. We're filing about a cert petition every 2 weeks at this point. So, understand that that's very likely to move forward. Now, the other thing to know is the Supreme Court often takes these decisions in big bulks. So you'll notice this year marriage was more than one case. It would not surprise me if you see guns again being multiple cases. So, that is a very common kind of thing. They will take a specific set of issues and run through that. The other thing that's coming to the Supreme Court, the NRA in Texas sued both the Texas state and the federal government over under 21 restrictions. Basically, the argument being that if you're 18, you are a citizen, you're certainly obligated to serve. There's no reason why you shouldn't be able to buy a handgun. And Texas, there's no reason why some under 21s can have a carry license, but some under 21s can't. I expect you'll see that as well, petition for cert here very shortly. So what have we done for you lately? This is only the last 3 months or so. We do a heck of a lot, and in fact, one of our problems is we're usually doing so much we forget to toot our horn about what we're doing. We sued San Francisco and Oakland because they were taking language in the Department of Justice's law enforcement gun release letter. The DOJ, after Kamala Harris has taken over, has done everything they can to confuse people. We enjoy making sure that people learn it the hard way, that being confused by Kamala Harris can be expensive and dangerous. People were having their long arms, which aren't registered, not returned to them. So, perfectly legitimate reason someone would lose a gun, there was maybe a domestic dispute, whatever issue, it's clear they go and get the law enforcement gun release, which is the way you get your guns back here in California. And when that comes back, you're supposed to take that to the property room, and they use that to say, okay, you're still not prohibited, here are your guns. These guns are also, and this is an important life lesson, if your guns are ever seized for any reason, you should get a pink receipt with every single one of them and their serial numbers on it. So these folks were coming with the letter in one hand and the pink receipt in the other hand, and they were getting their handguns back because the handguns are listed in the AFS, and so clearly they're theirs. But then the San Francisco property or the Oakland property managers were saying, well, we can't give you these back because they don't show up in the registry. They were never registered. So we sued. Quickly, real counsel got involved, realized we were right. The federal judge in question allowed the Attorney General out of the case, but not in a very nice way, and made it very clear to the cities that they were following the Attorney General's legal advice at their peril. At that point, both cities quickly settled, and it actually turned out Oakland did something unlike Oakland. The reason they didn't give one of the long guns back was it had a malfunctioning bullet button. But what they said was, if you replace the bullet button with a correctly working one, we'll give it back to you. There is hope for gun owners.
How do you fix it if you don't have it back?
The question was, how do you fix it if you don't have it back? They actually took it to an FFL with one of the cops, and they did the repair at the FFL. So, and we see that more than you think. There is a bit of a sea change, and this is partially why if something weird happens, please contact CGF. When we're involved, these kinds of things happen. Okay? San Francisco just didn't believe. In fact, even after we'd settled, our guy went to pick up his long arm, and the property master tried to not give it to him. To San Francisco Municipal Attorney's credit, she ran downstairs and yelled at him, and that was taken care of. But it was very nice to get a partial check from San Francisco to pay for our legal fees. Your gun donations got donations back from the government. About 2 years ago, it came out that when you called the Merced County Sheriff's License to Carry hotline, it would pick up and say, we're not taking applications right now, call back in 3 months. Click. That's a violation of California law. And so we approached Merced County Council and said that this was not acceptable, and your sheriff, he isn't necessarily compelled to issue, but he has to absolutely take the application. It can only cost so much. He has to review it in this time frame, and if he doesn't, he's violating the law. They told us something close to pound sand, so we sued them. And all of a sudden, you'll notice that if you go to Merced County's License to Carry website, you will find basically the Calguns Foundation's model carry license application process. It's not exactly perfect. There's still some issues for under 21s and those kinds of things, but for most folks, you will now be able to actually apply and get a determination in Merced County about whether or not you have good cause. I will say it still is a good cause situation, but I would call it closer to San Mateo County, in that if you do have good cause, you are likely to get a permit in Merced. Merced also kindly made a donation in kind to the Calguns Foundation. And obviously, we get a lot of mileage out of these decisions, because of course what we're doing here is making people into scapegoats. So we're running around to all of the other law enforcement agencies on the first point, and to the sheriffs on the second, and saying, look, you too can go through a painful, annoying process and do what we're trying to tell you to do, or you could just comply with California law, and here's how. So as you can imagine, these have great knock-on effects, and you'll see more and more counties continue to clean their carry license process up, charge you the correct fee, actually take your license and permit. Can't guarantee you're going to get them everywhere. You're going to get them a lot more places than you used to, though. But at least you're going to actually be able to compel them to do the right thing and follow state law.
Is there any hope for Santa Clara County?
Santa Clara County is hopeless until we get the Supreme Court. Basically, what we see is that unless you have bribed her, you're not getting it. If you do bribe her, you may get it, and if you don't bribe her and have equal good cause, you probably won't get it. That said, as I said, she's already sued. That case is pending holding for Richards versus Yolo is exactly the same issue. Depending on how both the Court of Appeals and the Supreme Court goes is how Santa Clara County will go. And obviously, we will make a lot of noise when it's time to apply. Okay? Some of you may have noticed that all of a sudden there are no more new semi-automatic handguns ever coming to California. It's called microstamping. The patent holder, some of you may know, we did a little hijinks. We extended his patent because he was too lazy to cancel it. We were actually worried he wouldn't cancel it. You can actually recover a patent in certain ways. So we bought ourselves about 36 months, which I'm pretty proud of, for $400 or $500. But he did actually go through the effort to abandon his patent. And so Kamala Harris has adopted microstamping in a new semi-automatic handgun to get on the certified not unsafe roster. I love that Orwellian name. Must have microstamping. Of course, we're unsure of any manufacturer in the United States that knows how to create a microstampable handgun. This is actually in some weird ways good news because, as you know, we had a case pending called Pena. Pena is about 4 people who want to buy firearms that aren't rostered. One of the firearms they want to buy is the exact same revolver in DC versus LA. It's the one gun we know. The Supreme Court has said you must register if this person is not a felon. But a bunch of the semi-automatic handguns don't have microstamping, and so of course there would be no way to add them to the roster even retroactively now that microstamping is in place. You should expect a significant motion on that in the next 60 days. These Supreme Court cases have actually held up a lot of the time. One note, just know that there are only so many very good firearms lawyers in the nation, and right now they are all exceedingly busy. Oops. So, some of you may have heard about a new documentary that just came out called Salted. Both SAF and CGF helped initially fund this and pull pieces of this together. This is a very important step in kind of the educational mission about the value and the use of firearms. The documentarian here is a known PBS documentarian. He made 200 Years of the Telescope, which got a couple Emmys. The next showing of this is going to be in Oakland on July 10th. It will sooner or later end up on Netflix and all the kind of usual suspects, but right now it's in limited theatrical release. You should check out deadpatriotfilms.com to find where it is, and also if you get enough of your friends together, you can actually get theaters to actually put on showings for you. It's much less than you expect. So please check that out. This is important for 2 different things. One is, this movie is never going to take a hardcore anti and change them. So don't expect that. But for people who are low information voters on this issue, and you know you have these people in your family, it's going to tell them a very different story about why firearms are a social good. Because that is the story that does not get told enough. People, the assumption when you read a New York Times anti-gun story is that guns are only bad for society. Of course, no conversation about defensive gun uses or the modern times that firearms have fought tyranny. So this is an excellent modern historical review of where firearms have progressed the civil rights movement, saved countless lives in Koreatown and Los Angeles. It's an important story. And the reason I tell you to see it is there are a lot of these stories that you've only maybe heard about or don't know the historical accuracy of. If you add to your repertoire the ability to tell these stories, it changes the conversation. You can take things that progressive liberal folks hold very dear and explain to them that the reason that Martin Luther King frees the South is because everyone around him was armed. People don't think that through. They forget that the KKK is the sheriff, right? And no one draws it to the fact that literally the Black Panthers and the reason we can't carry in California is because of that, right? So being able to tell those stories, I just can't say enough about how well this explains emotionally and historically the value firearms have had in the 20th and 21st century. What can you do? Follow us on Twitter or follow us on Calguns. Like our Facebook page. The main reason to do that is that we do a very good job of getting the information you need, bills, everything else, directly to you. The other piece is we have an interesting setup with Amazon. Yes, Amazon is not exactly the gun-friendliest entity in the world, but darn, it's convenient. If you go to shopfor2a.com it'll redirect you to Amazon. Everything you buy, we get somewhere between 3 and 10% of. So we make about $9,000 a month off this. If you pay about $80 and become a Prime member, everything will show up in 2 days. Buy your toilet paper, buy everything you want, and it just shows up. It's exceedingly handy. So not only can you make your life a little simpler, you can help the gun rights movement by buying stuff you're going to buy anyway. But look, if you don't want to do that, direct donation matters. The good news is we have a very large pile of cash, so we are ready for what we have to do here. The bad news is we have a tremendous amount to do. We have to spend a lot of legal fees from here to there to be able to roll back the tide that we are going to face post-Newtown here. So you can see the URL, it's calgunsfoundation.org/donate. And look, you've heard enough of me talk. You guys have questions, that's what I'd like to do, so please don't be shy.
Before you start the questions, I'd like to remind everybody, you're asking questions, you're not making speeches. Please come to the point, make a question, don't make a speech. Thank you.
Are you expecting any movement on Palmer in the next 5 years?
The question is, I'm expecting any movement on Palmer in the next 5 years. First, what's Palmer? A few weeks after DC versus Heller, Alan Gura filed a Kerry case in the District of Columbia because, of course, incorporation didn't matter. That case is still in the district court 4.5 years later. This comes back to what I was talking about the court stalling a bit. The reason I expect that court case hasn't moved, there was a legitimate delay, which is there was a very well-known NSA secrecy case that has nothing to do with the current battle in front of the same judge who had it. So that cost us 1.5 years. But since then, it's just, frankly, unjust that it sits there. The DC Circuit is actually quite gun-friendly. Of course, this is where DC versus Heller, we won the Court of Appeals. It's called Parker versus DC at the time. So I think it's a little bit of the judge not necessarily wanting to give us a decision either way because he's worried about what the Court of Appeals will do with it. But it also is our ace in the hole because to the extent that we have problems in the rest of these courts of appeals, it may end up being that we have to do exactly what we did in DC versus Heller and go through DC to get Kerry.
Yeah, about a month ago, there was a push to get a bill going through the California Assembly that would grant Oakland exception to the state preemption laws. I believe they did pass a similar law allowing LA variance to the law. I was wondering if you, I tried to find some more information on it recently, but didn't see anything on it.
Yeah, I believe it made it, let's back up. The question was, there's an attempt to exempt Oakland from the statewide firearms preemption. And there was a successful bill in LA to exempt them from some preemption. Now, in LA, let's be very specific, it actually was BB gun preemption in Los Angeles only. So it turns out that we actually have stronger BB gun preemption than we do firearms preemption. It's an odd quirk of California state law at times. There wasn't a lot of opposition to the LA BB gun situation because it was only BB guns. There is a strong opposition to Oakland doing this. And by the way, not necessarily just from firearms owners, there's other reasons why other folks don't want it. I do believe it made it out of its house of origin. I'm not sure it's going to make it across the rest of the line, if you will. Especially when you're dealing with those very micro-targeted bills. It's kind of hard for them to pull together coalitions to get them passed.
A lot of the laws that are put out are, to me, obvious infringements on the Second Amendment.
Sure.
Infringement. But no, I've heard of no case that says to the court, this is an infringement that is unconstitutional.
Almost all of these cases do. So if you go read what, for example, we say in Richards versus Prieto, may issue is an absolute and total infringement. It doesn't pass any level of scrutiny, and it doesn't even require scrutiny. It turns out it is what's called a permit term. Apologies. No, it's a restraint. I'm switching a word. Prior restraint, because basically it assumes that you're not necessarily able to exercise your right in the first place. You won't often see the word infringed used because that's not generally how the court thinks about constitutional rights. Even when you're talking about Congress shall pass no law about the freedom of speech, we don't say they passed a law. We say it infringes the First Amendment. to some extent, not legally. It would be that it doesn't pass strict scrutiny in that case. So the kind of open question, the reason when you read any of the things you'll see us all filing is, the only thing we know for sure is that rational basis isn't the way you look at gun laws. Okay? Now, look, judges are being dishonest. This should be expected. Anytime you talk about a civil right this light, you're going to have dishonest judges. And look, if you want to get a history lesson on this, you have to look at the African American Civil Rights Movement. It is ugly what judges were willing to say at the district court level in the South. Okay? Now, what happens is when you go up a level of the courts of appeals, that's usually where you start getting much more rational conversations. So, for example, the Seventh Circuit is not exactly our friend, but two of the most important Second Amendment cases have come out of the Seventh Circuit, both Ezell, which, by the way, says you have a right to train, gun stores have a right to be open. We never thought we'd get all of that quickly, right? And they say all but strict scrutiny is how you analyze this because it wasn't a very direct claim, right? So what we're out there doing is figuring out whether we're going to deal with true strict scrutiny, a version of strict scrutiny. In fact, if you read Heller, what it probably means is we're going to do a very historical analysis. People sit here saying, look, the felon ban isn't something that historically was in place. They're correct because you usually hung a felon. So it doesn't really matter whether or not there's a lifetime ban on firearms. He didn't possess a firearm after he was convicted of a felony because he didn't get a gun between there and the gallows, right? So historically, the felon ban actually has a pretty strong history in what we thought was the right to arms. And even Don Cates spends a lot of time in his books talking about the mentally ill or the known drunkards were easily disarmed, right? So those things from a historical analysis, it's why I was talking about with magazines that I think the import ban goes right to the heart of the Second Amendment. When you think about what the colonial army was worried about, it was the British stopping the import of firearms and powder, ammunition. I think back to our ammunition bill we're talking about. So it's either going to be what is kind of called historical categorical analysis, and we've actually seen that in dissent in the District of Columbia over assault weapons. We basically saw a very well-known jurist there say, look, the historical categorical analysis, there's no way the AR-15 doesn't pass it, because even if you were trying to talk about good guns versus bad guns, handguns are what caused all the crime. If handguns are protected, there's no strong argument that a rifle wouldn't be protected because they're not used in crimes, right? And that would be kind of the historical thing, plus it's probably the militia weapon. So open is the question of exactly how the courts are going to handle this scrutiny question. Because the courts have approached it with such perfidy, it would not surprise me that the Supreme Court may decide to go a little further than they otherwise would have to explain to the courts, no, really, we mean that you're using strict scrutiny. Now, even still, that means you're still going to talk about where the right ends. So just like in free speech cases, that libel and actual fighting words and kiddie porn are outside of the First Amendment, right? There are going to be things that are outside of the Second Amendment. So that's the other major battlefield. Now, what happens today is courts go in and say, well, carrying arms, that's outside of the Second Amendment. And even if it were in, we're going to use intermediate scrutiny. And somebody might misuse that, and that's enough. These are all wrong. But I'm just telling you that that's currently what we're facing in courts. Now, as I said, not all the courts are that bad. D.C., Illinois, when you create these splits, that's the Supreme Court steps in. And as long as we continue to have the Heller 5, please vote Republican in the next presidential election. Regardless of your otherwise leanings, then we have a strong sense of the ability of the Supreme Court to actually go and extend and explain how you analyze these laws, which things are inside the Second Amendment.
So I was at the Second Pennsylvania City Council meeting the other day, where they were talking about some of these amendments, propositions to try and pass. One of them was requiring locks, guns to be locked, to have a lock in them, which I believe there's also a state law that go through there. The DC case was said you have to have an operable gun. Well, me putting a lock on a gun makes it inoperable. So that basically means is that true? Do you agree?
Yeah. So the question was, these mandatory locked storage laws, effectively, are these constitutional? The answer is Hell's already answered that question. You may be able to require other guns to be locked and not, do you need more than one gun unlocked will be something we'll have to find out. I think the answer to that is yes, because it's a fundamental right, but ignoring that, already San Francisco has passed this, and already it is being challenged by the NRA. And it's one of the easier cases in some senses because Heller is already on point on operable firearm, and that the long arm locking was unconstitutional there in D.C. That also helps the argument of more than one firearm because, of course, you have a right to a handgun. You can't require that your long arms be locked, etc. Now, you said maybe there's also state law. California state law is actually decent here in that it implies liability on you if your firearms are taken by someone who shouldn't have and then misused, right? Even Texas has a very similar law. There are proposals to make it so that you have to lock everything up all the time. It's a yee bill. We'll see if it goes anywhere. Again, welcome to, I've only scratched the surface of how bad everything actually is out there, but.
Sure. Me?
Yeah.
It's kind of related to Brad's question. I noticed that cities like Sunnyvale and Santa Clara County as well are trying to pass measures that almost replicate the bills that are coming up before the state right now. Is CGF aware of those, and do you have a comment about that kind of trend that they're kind of trying to do an end run in case the state stuff doesn't pass?
Yeah, the question was why, notice that all the localities are trying to pass the same sorts of things the state's trying to pass. What does CGF think? Are we aware, et cetera? Look, the artist formerly known as LCAV, it's now the Law Center to Prevent Gun Violence, because apparently they're not against violence, they're only against gun violence. It's where all of this comes from. ABAG, the Association of Bay Area Governments, is what it all gets followed through. Let's just put it this way, we are very, very well aware of what's going on there. Sometimes I like these municipalities to pass these things because they stink defense. There's an interesting pattern here of I'd really like the most broke cities and counties to pass the worst gun control because it's more fun to beat on the poor kid. There are, however, a lot of escape valves when we're talking about this from a litigation perspective. And what I mean by that is that the state laws, it's much easier for us to go very directly at them with a Second Amendment challenge. When you deal with these city laws, you also can throw in things like preemption and whether they actually have the power and all that. And it allows a judge who knows we're right on the Second Amendment to duck the Second Amendment, strike the ordinance, and have it been a bunch of wasted time for everybody. At least we get paid. So we want to stop these things first. I will tell you that a lot of the cities are only starting to understand because we start telling them what Chicago and San Francisco and everybody else ends up paying for these. And so you actually even see the San Francisco municipal attorney begging the San Francisco board of supervisors to not pass the magazine ban because they expect that they would just lose and pay. Okay. As we continue to do this, this is the number one thing. But look, folks, it really does work when you turn out and you push on this stuff. I mean, as much as the Templar sports situation continue to get a little weird, they know it's going to be painful, and they know they've attracted, if you will, all the attention that's necessary to make it extremely painful. Now, on this, one case I didn't mention is Taxiera. About 18 months ago, a gun store tried to open in San Leandro near the Walmart off 880, and their conditional use permit was granted and then pulled. We think that the Zell makes it very clear that you can't do crap like that in the localities, and we think that zoning is going to be a big place to play here. We actually expect that to be a very important case, and you start to hem in the municipalities on what they can actually attack because it's becoming clearer and clearer that, yes, gun stores do some protected Second Amendment activity. It should not be hard like a bookstore does in 1A, but hey, details. That it becomes less and less interesting politically for them. But look, I asked you guys to make sure that we're made aware of it because we're really easy to find. If there's one we're not, aware of, please get it to us. The more lead time, the more often I can get one of our board members there. You will see you will see us get up and say, "We're excited to take your money."
Okay, you talked in their start about a national strategy. Now, are you talking in terms of if we pass CCW at the federal level, there's a daisy chain effect with all the other laws, or is there some other kind of, what do you mean by strategy?
So the national strategy on carry is primarily SAF and its affiliated organizations and the litigators who've put together in all of the states that have carry licensing regimes that aren't constitutional. Now, certainly inside this room there will be people who would argue with me that some of the states still have unconstitutional measures. Some states will allow what's jokingly called the naked man exception. So in Colorado, if the local sheriff has a pretty good reason why he doesn't think you should get a permit, then he can actually deny you a permit even though it's a quote shall issue. And it's actually surprising how many states have that. Now, they're very rarely invoked, and then they're usually required to have basically strict scrutiny or the civil equivalent of it. But, you know, if the sheriff can walk in and talk about the number of times that his deputies have picked you up running around naked in the streets, drunk and crazy, you can imagine that the local judge doesn't necessarily grant that permit, right? Those have to be the exception. Now, backing up, there is some coordination between litigation strategy and the federal House and Senate. So if you read closely what the national reciprocity laws currently are kind of designed to do, they're designed to be what's called a 49-state permit for may issue and a 50-state permit for everybody else. So the way this works is, if you were a resident of Nevada, Nevada's a shall-issue state, you get your Nevada permit. The moment you got your Nevada permit, all other 49 states would be required to honor it, okay? But as Californians, we can't get our California permit in most of the coastal counties, as we all well know. So you can go get your Utah and carry in the other 49, but not your own. This gets into the politics a little bit of states like Texas and others want their residents to take their course and not somebody else's course. You know, when you think about federalism, there are some reasons why we have to kind of be careful there. But the whole point of not making it all a 50-state permit, because of course the federal government could make it that if a Californian got an out-of-state and couldn't otherwise get his, but otherwise could get somebody else's, that he could carry here, is to not moot all the cases on carry. So the idea is to have enough of these cases that we create a circuit splits. The Supreme Court, sitting with the current 5, will make it very clear that bear means to carry, just like they said in Heller.
My understanding is that the federal 1934 Gun Control Act is based on weapons that could not be used in militia. That's how they banned like Thompson, because I guess at that time they didn't use them. They wasn't used in the military. Doesn't that set some precedent for modern times, such as the AR-15, which certainly would be a militia-style weapon, or that's all been forgotten in the last 8 years?
Yes, the question was, you know, Gun Control Act of 34, National Firearms Act, actually, Gun Control Act 68. The reason that it was upheld in the Supreme Court, arguably, was that a sawed-off shotgun wasn't the kind that a militia member would show up with. Of course, the plaintiff, the defendant, was dead. His lawyer didn't show up, and what may be the worst Supreme Court justice ever is the guy who wrote that opinion. The court in Heller struggled with this because you will note that until the Solicitor General raised it, machine guns were very conspicuously absent from the conversation. In the near term, it is unlikely, and we kind of call this the Heller modified Miller. Miller was the case in question test. If it is a modern firearm in common use in the civilian supply, it's protected. But if it's not, it's probably not. Now, we all know there's some circularity there, right? The reason that there is not a lot of automatic weapons available to the common folks is because of the 86 Hughes in it, right? But look, let's put it this way. You hear how hard it is to get the right to carry. Simply a handgun, simply a round. Let's make sure we secure that, and we secure the AR-15 and the fact that you can have a 15-round magazine before we worry too much about whether we should be able to buy machine guns. We can wait back and then come back forward.
This evening you talked about CCW. You explained the difference between constitutional carry, how it compares to physical carry, states in our nation that do offer that, as opposed to states that their legislature has it on the books and they plan to pass that soon.
Okay. So the question is, can you explain the difference between concealed carry, constitutional carry, you know, the constitutional significance of that, states that do and don't have it. So, you know, look, 25 years ago, it was very hard to carry a firearm in most states, period. You know, I think people lose sight of that to some extent. You know, in the South, people could still open carry. And in fact, there's a surprising number of what I call classic Western open carry states where you could either open carry or if you were voyaging, you could conceal carry. The idea being that if you were riding from town to town, you know, you'd either be bringing your stuff or you'd actually be able to carry it concealed. California was an open carry voyaging state until the Black Panthers open carry in Oakland. There's two different analyses here. I mean, the good news is that from a gun rights perspective, you know, Vermont never, ever banned any method of carry. So if you talk about constitutional carry, it's really Vermont carry. Because since 1912, Vermont's Supreme Court took the Second Amendment seriously, considered it part of their constitutional Rubicon, and said that you couldn't license concealed carry or open carry. So in Vermont, anybody who's not a felon can carry any method they like. After Florida, through the 80s and 90s, we saw a wave of people liberalizing carry permits so that people could get at least a license to carry. Now remember, there are a lot of states that ban open carry, including such rabidly anti-gun states as Texas. Okay? And some of this has a lot of history to it. There is an urbanification, if you will, from the cowboy West to the modern West, that a lot of societal people who otherwise like guns do not necessarily want to know that everybody around is carrying. What the Supreme Court said in Heller was that it looks like the manner in which you carry can be regulated. Because the historic cases here were that as long as, for example, open carry was allowed, you could outright ban concealed carry. Okay? Now, it looks like the reverse is also true, that if you outright ban open carry, you can't ban concealed carry. As a constitutional matter, it's probably problematic to have a state that bans open carry and makes it even slightly difficult to get a carry license. And by slightly difficult, I mean pay a fee. But I have to tell you, the political reality today in the states in which this issue matters, the translation to states that haven't already passed constitutional carry, like Alaska or Arizona, right? Or the ones that are likely to pass it, Idaho, for example. But again, you've got some crazy pro-gun states that will not go to an open carry or a constitutional carry environment. So understand this is a bigger issue than just what the constitutionality is. But as I was saying, the states that are going to be the hardest, the holdouts, New Jersey, New York, here, Illinois, I think we're going to have to be comfortable with shall issue and reciprocity for concealed carry. Plus, there's a pragmatic piece here. I mean, if you've watched the Starbucks open carry war, the anti-gunners very much want to try to use Starbucks against us. And if you get into a regime that is open carry only, it's not clear that everybody will do what Ohio did. And let me tell you a quick story. Ohio has an actual Second Amendment analog in its own state constitution, so there's no question that there's a right to keep and bear arms in Ohio. But it was a made issue in jurisdiction for quite a while. And then someone kind of wisely decided that, hey, wait, we can open carry. And so they started open carrying, and they were arrested for it. Of course, they weren't breaking any laws to stop them being arrested. They took the case all the way up to the Ohio Supreme Court. Now, the Ohio Supreme Court ruled that the arrest may be invalid, but the concealed carry restriction was constitutional. And one of the Ohio Supreme Court justices wrote a very important dissent that said, and of course that means that you get to open carry, and if you're arrested again, all the police officers are now on notice and do not have qualified immunity, that if they arrest you, they're violating your rights. And about 6 weeks later, a shall issue concealed carry bill passed the state legislature. I'm not sure that would happen here. Okay, our legislature hates us so much that they would rather force us to open carry and expel it. So be careful what you wish for. I'm not sure that an open carry only right in California is exactly the way we'd want to go. I think that being forced to obey the signs would be painful. Look, I like going to the Giants game, and I went to a concert last night, and I am one of those lucky few, and it says no weapons, but it's not on the law, and I don't care.
I keep wondering if we had a third party based on the Second Amendment, if you think that would pull some of the Democrats and some of the Republicans.
The question was if we had a third party based on the Second Amendment, would it pull some of the Democrats and the Republicans? We do. It's called the Libertarian Party, and we suck. Now, look, there is some political realignment going on out there. You're starting to find, and it's one of the things we've strived to do, there are a lot of folks who are otherwise of the left that would not agree with us on Obamacare, would not agree with us on other things, would absolutely agree with us about firearms, about the NSA, about a lot of these issues that are, shall we say, front and center right now. So from that perspective, I think there's real opportunities, though. I've got to tell you, I think here, it's that we've got to reinvigorate the GOP to be a bit more open-tinted for those folks. We've made a very good job of not winning anything in California with the GOP here, witness 2/3, right? We'll go, Jack.
Is there anything in the recent Supreme Court rulings that would help bolster the cases for right to carry, like federal or state level, can we move forward from here on out?
Question was, is there anything in the current cases in this last session that is valuable for right to carry and the Second Amendment? Two things, one of which almost no one will be aware of, and one of which may make some sense. The DOMA decision actually has some interesting pieces to it as we get past the basic right to carry in that when we're talking about reciprocity and other states need to honor these licenses, you can see the parallels to the DOMA decision that's not up to the states to not honor the action of the state around a fundamental right, right? However, there's another one, and it's a fun little case out of Long Beach called, oh gosh, I forget the name. There is a massive preemption of all trucker and shipping regulations. It's called the FAAA. And for whatever reason, the lower courts really don't like it. They don't like applying it. The Port of Long Beach made it so the truckers, pardon while I get around this to understand why it matters to the Second Amendment. They were forced truckers to buy these special forms and change their engines to not belch so much sulfur, and on and on and on. And a whole point of the Interstate Commerce Clause is that the federal government said, no, you're not doing this to airlines or truckers. Well, you'll notice that California keeps liking to make certain importation of certain things illegal. Well, the way you do that is you tell the FedEx truck you can't bring the ammunition in. Well, Supreme Court ruled 9-0 that yes, all of these regulations at the Port of Long Beach were preempted. And so, in fact, we think a lot of what California tries to make illegal to import, which are completely common stuff that no trucker would know any different on, is actually very prone to challenge under that statute.
Question about the handgun roster. Like, I've heard of a situation where somebody who obtained a handgun through PPT or SSE that tried to send their firearm to like SIG, and they told them that they would be able to send it back to them because it's not on the roster, which in effect basically kills your firearm.
So, unfortunately, some gunsmiths and repair shops and such don't understand that the roster does not apply to repair. If you have that problem, shoot us a message, not on the hotline, but on the info line, and we'll see what we can do to help you educate someone that the roster doesn't apply that way. Now, as much as I just said that, there is a bill that would try to make it so you couldn't transfer an unrostered handgun, period, in California. Again, I don't expect it to get a whole lot of traction, because I think the governor's not going to like its implications about stranding your property. But
earlier on, you touched on the fact that the Supreme Court's sitting on some cases for an awful long time. At the same time, you've been threading into your discussion what are common firearms, common use firearms, and then I'm looking at what the state of California is trying to do. My brain is saying to me that there's two goals going on here with the state of California. One is overt. We're trying to ban this, ban this, ban that, ban that. Covertly, my brain's telling me that what they're really trying to do is they're trying to use the law to define in California what the common firearms are, not semi-autos.
So the question is this delay?
What may be going on here?
Yeah, the delay tactics, and I want to clarify, you said the Supreme Court, I'll come back to that, and the courts, and what California is trying to define as uncommon, in a sense, combined. No and no, and let me explain why. First of all, the courts that are delaying are not the Supreme Court. The Supreme Court is exceedingly punctual. Everyone knows how it operates. It's rare that a case takes more than, next term. Once in a while, the holds cases over across terms. It's very rare. It's the courts below them that are holding back. Now, the question was, okay, so if California is successful in prohibiting all these firearms, will all those firearms fall outside the definition of common use? The District of Columbia for 35 years made handguns extremely uncommon in the District of Columbia. And the Supreme Court looked to the entire nation's gun supply to see what was in common use. So, could a court with perfidy try to use that rule? Maybe. But will that actually give them any traction? No. We're going to be looking at what is common in 50 states, not just in New York and California. And look, the funny part is that registration cuts both ways in California. If Steinberg's bill were to pass and be signed and we all have to register, I'm going to ask you to register firearms that don't exist. It's not a crime. I want you to register everything you own for free. Keep a couple aside. You can make them, if not, with Las Vegas. Do whatever you do with them. But the more AR-15s that are registered in California, the more common they are. Way in the back. How are we going to fight the UN Arms Treaty? It'll be interesting to see if the Senate will ratify it. When you start thinking about the numbers for gun control there, and you look at what happened with the federal gun control bills and then the number of people who voted for carry reciprocity. Carry reciprocity got 57 votes in the Senate. Okay? It's not clear to me that the Senate will ratify it. It wouldn't surprise me that Obama will sign it, and it doesn't really matter. To the extent it is signed, look, it is absolutely a framework intended to try to mess with our rights. I'll be very clear, okay? But people need to know that there are two parts of the trade treaty, and I think we've actually had some talk about this at one point. Even though the State Department and others overreach this once in a while, what's called ITAR, the National Traffic in Arms Regulations, do actually exist to do things that the federal government is supposed to do, like keep us from privately trafficking firearms to the wrong side of a civil war. Okay? You know, we gave the federal government foreign policy power, and they get to, you know, handle that. Now, the federal government has no ability to stop import of firearms. So every time you see somebody talking about these M1 carbines can't come in, that's massively unconstitutional. Okay? So to the extent that the Arms Trade Treaty is actually codifying something we do today already. So if you want to export a firearm or a magazine, you actually need a permit. It's shall issue, it's easy to get, or you use an FFL. But, you know, that stuff is already there. What they're trying to do is to get the rogue countries to play along with that, so that we at least know where guns are going. Again, at the, you know, civil war, mass disturbance, genocide level, right? However, of course, what's really going on is what's called IANSA is trying to then take those rules and make iterative changes so that the possession and use of even small arms for us is not allowed. The Supreme Court has a very strong history of basically telling treaties to pound sand when they come into contact with even federalism, much less the Bill of Rights. Now, look, there's a risk that we lose the Heller 5. It gets passed, it gets signed, the Senate passes it again. I think that's unlikely on the Senate side. Then that's where there's some real trouble, is you might have the Supreme Court go 5-4 the other way, that this is, you know, the new world power and we should go that direction. So it is something we need to oppose, but also understand it's somewhat unlikely to finally see the light of day.
Speaking about firearms that are illegal, is there any hope that firearms like the Judge are going to become legal in California?
The question is there any hope that some firearms like the Judge might become legal in California? I would say some. The issue is that the category of firearms you're talking about is such a narrow category that it's going to take some time for those to be priorities to fix in some senses. So in the case you're talking about, the Judge is considered a short-barrel shotgun here in California for really inane reasons. The good news is there's not a lot of stuff in that category that falls in those cracks. Bad news is it will only be able to be fought in California because it is such a kind of unique prohibition. You know, comparing that to, like, for example, the AR-15 or, you know, the fourth generation Glock, right? Those are going to be so mainstream and so important that those will be challenged pretty directly. Maybe, but it'll be a few years. We've got a lot of stuff ahead of that.
Going back to the San Francisco lawsuit against the importation of magazine, I understand it's a civil case. Do you see any scenario where things go south and defendants are required to produce a customer's list?
The question is, would the magazine case in San Francisco force the defendants to produce a customer list? The answer is there's always a risk. I will tell you that, you know, obviously we want to make sure that doesn't happen, but just being on that list isn't probable cause of reasonable suspicion, okay? So I would counsel you this. First of all, don't worry about it. Second of all, if a police officer ever shows up at your door and asks you any question about firearms, ask him if he has a warrant. Be nice about it. But if he doesn't have a warrant, tell him to go away. Don't let him in your home. Maybe call us, but I doubt you're going to have that happen. To give you an example of this, so the Armed Prohibited Persons List, okay, this is the money that Kamala stole from us gun owners in the Drost Fund and is using it to send 9 DOJ agents out on double overtime for 5 hours in their car because it's kind of fun and they get paid. They can't get warrants, okay? So people known to be banned from owning firearms that have firearms listed in the registration database, the DOJ can't get California judges to give them warrants with that level of data. You're not going to get a warrant issued against you for having bought a magazine repair parts kit. And always remember that possession isn't illegal, that it is perfectly legitimate to own parts kits to reassemble them out of state at competition or at training, And frankly, as long as you've gotten or have a good reason that you would have had magazines prior, that you're completely legal. Plus, the crime of importation or manufacture, which is what's banned in the magazine case, has a 3-year statute of limitations. So I joke that having records that you assembled it 3 years and a month ago are actually kind of handy. Just don't have them during the first 36 months.
If I understand this gentleman's question correctly, and I'm just doing a little bit of computation, if I have a registered assault weapon, presumably there would be a presumption that I do have standard capacity magazines, and unfortunately I do live in the city and county of San Francisco. Would I be on some list when I get my door knocked in the middle of the night?
So the question is, if you own a registered AW, and the assumption is that you probably have standard capacity magazines from back then, would you get a door knock? Absolutely not. In fact, if anything, it would probably be the least interesting to them because you have an absolute legitimate reason why you would possess them. What the antis in San Francisco are all up in arms about is that people have realized what their Swiss cheese law this actually is. And if you listen to what I've just said, it's Swiss cheese. They're unhappy that the parts kits are available for sale at the Cow Palace show, and that, you know, we can imagine what people who are 22 or 23 are doing when they get home with their otherwise full than they are. What I'm saying to you guys is that even if, in a civil case, the customer list of these out-of-state sellers was forced to be turned over, I don't believe that the local police would be able to get a warrant at all. They might come knock and talk and ask you why you bought magazines, and the answer is none of your business go away.
I wasn't referring to repair kits. I was referring to some people in this room own magazines from the 90s.
Most people in this room own large capacity magazines from $3.99. I know I do.
Speaking from so that, it would be a cross-checking of that official registration.
Let's back up. Possession of large capacity magazines is not illegal. Say it after me. Currently.
But I don't trust those people.
In LA has passed a retroactive ban.
Okay.
We will sue them shortly.
Thank you.
Okay? San Francisco is considering it. The San Francisco municipal attorney, even though they're going after parts kit, is begging the supervisors not to pass it. Okay? If it passes, the worst case scenario is take them apart temporarily.
Did I understand you correctly that you said there was a statute of limitations on high-capacity magazines?
The statute of limitations on the importation of or the manufacture of a large-capacity magazine is 3 years.
Interesting.
Gene, what's your thought on 8% lowers or printed lowers at this time?
Oh, printed lowers. Let's just say that 30% of the board of the founders of Calguns Foundation were involved in this little thing in the late 90s where we printed a book with the source code to cryptography and got the Department of State to stop regulating cryptography. You can imagine we're going to be very involved in 3D printing of firearms parts. The magazine cases have actually held us up a little bit, otherwise we'd have a little more news sooner. You know, you should keep an eye on store.calgunsfoundation.org because you might be able to buy some really interesting mementos from there.
On the subject of rebuild kits, if you have a $3.99 magazine that is damaged and no longer works, what is the correct protocol to fix that?
Buy a full repair kit, buy a part, take the parts you got, throw them away, and don't worry about it. If you have a problem, call us. We'll fix it.
Oh, God.
Yeah, the question was if something's made illegal and there's no easy way to sell it or dispossess yourself of it, is that going to be threatened? Look, we will raise the Fifth Amendment argument. I have to tell you that the Fifth Amendment jurisprudence is weirder than you think it is. In physical property, real property, you know, the taking stuff is well known. In things that could be considered nuisances, and that's why they always use the word nuisance when they start talking about taking these things. If you harken back to Prohibition and some of the other things that have happened, we actually have a history of having stuff effectively taken. Now, there's a more recent Supreme Court case about eagle feathers. The eagle feathers are now protected species, and so you couldn't sell them, but at least you continue to possess them. And that was constitutional. What the Supreme Court said was that if you, it implied that if the ban would also then make it illegal for you to continue possessing them, there'd be a problem. But look, the reality is that this stuff is components of arms in common use, period. People don't have a sense of how many magazines, more than 10 rounds, there were in the world. During the assault weapons ban, something like 175 million magazines were licensed to be imported into the U.S. in the 10 years in question. So, you know, when you start talking about are these things common, it's actually pretty easy to prove they are. And we, in many ways, would prefer to go right at the issue and say, we're being infringed, these are common parts of firearms, and you can't ban them.
I got one more question.
Sure.
So at the city council meeting the other night, one of the councilmen made the point on the ammunition registration things. When you got to go to the store to register, he says you have to, when you buy Sudafed at the drugstore, you've got to swipe your license and basically register yourself because that's in the public interest to keep people from making meth. Well, the ammo registration is the exact same thing, and so how do you counter that argument?
My favorite argument to counter the, well, you know, we have to show ID for meth, and therefore we should have to show ID for ammunition is, well, I guess we should show ID to buy a Koran too, because that would stop terrorism. And it's really interesting to start going down that road. I mean, do we need IDs for abortion or voting? You know, when you go down that, you know, look, it's already illegal to possess ammunition if you're prohibited. You know, if we're really dealing with it, I'd like to ask the question of why the cops haven't gone after the prohibited guy instead of going after Russell law-abiding. The bigger problem, too, is that there's a practical issue, and it's one of the things you can kind of talk about, which is those of us who are law-abiding buy a hell of a lot more ammunition than those of us who stick up liquor stores. Do I have any idea when there'd be a gun show in Alameda County? You know, there's this guy in the room, he just walked in, and he might be able to give you a hint. Impromptu.
How did you time that one, Don?
We've been negotiating the contract with the Alameda County Fairgrounds, and by the way, the people who actually run the fairgrounds are pretty friendly towards us. They can't wait for there to be another show. It looks like it will be sometime in October this year. Firearms at the show will have to be tethered in some way to the tables, or and we outlined about 6 or 7 different ways that can happen. So if you've been to any of the more, I guess the newer upscale gun shows, like the ones they put on at the NRA convention, where guns are actually tethered with a cable, a retractable cable to the display, that's probably the most likely thing you're going to see. The county, but not the fairgrounds, are still insisting that they get to ban ammo sales. So we've got a complaint ready to go. The county knows that we're going to sue them as soon as we ink the contract. And we'll sue to get the ammo sales. Right now, our contract is going to say that pictures of ammunition are going to be displayed on the tables. You can place an order, you can buy the ammo, and Gene and I are working on some private property in Alameda County, somewhere near the fairgrounds, where you can then go pick up your ammunition. Which actually, by the way, is probably more convenient, because if you've ever had to lug around 1,000 rounds of ammo around a show, you know, it's kind of a pain in the ass. So the idea that you can place an order inside and then just drive up to a drive-through or something somewhere off the fairgrounds property to pick up your ammo is probably pretty convenient. So maybe we've got a new marketing plan here to boost ammo sales, and that's kind of where we're going to go with that. Now, what was real interesting, though, during the negotiations is the moment we said that, you know, since we can't possess the ammo on the fairgrounds, but we can still sell it, then we're going to use this process. Well, there was somebody from the sheriff's office and somebody from the Pleasanton Police Department, and all of a sudden they woke up and said, what do you mean, there's going to be like a semi-trailer of ammo somewhere in the county? You know, dispensing ammo? We said, yeah.
Vending machine.
Truck noise on it.
And they said, well, we need to know where that's at. And I said, well, it's going to be on private property, so, you know, and we'll provide our own security, and so you don't need to worry about it. They said, but we have cops and sheriffs and security here. Why can't you sell the ammo here? Let's talk to the county, because we're not the ones who are trying to do it this way. They're imposing it. They go, well, we're going to want to know where it's at. And I go, well, talk to the county, because quite frankly, it's none of your business. Once we sell the ammo at the fairgrounds, where our customers go pick it up, as long as it's on private property, is kind of none of your business. Anyway. The art of that deal was inspired by Mr. Hoffman.
So remember, every time everyone tells you that nothing ever gets better in California, we win nothing, that you should enjoy going to the Alameda Gun Show. Also, one quick note, part of the reason why it's taking a little more time to get the gun show back is, well, because there were no guns to sell. Do know that that's actually had a little bit of an impact. The channel's now back to normal a bit, so we actually have guns and ammo that you could potentially buy.
I have a question for you, and then I want to explain to you why I bring this question up. First of all, the question is what are you doing to probe, to find out what exactly Kamala Harris is using to cause all these delays or near denials on people who are trying to purchase firearms? And I'll tell you where I'm coming from, and you can give us a quick answer first.
Yeah. The question was, have we probed into why or how Kamala Harris is denying people their drosses, basically? We know exactly how she's doing it. We're suing her about it already. What she's doing is she changed the policy inside DOJ so that if they check the records and there is an open arrest without a closure, then they will not allow the firearms sale to proceed. The policy had prior to that been that if the arrest was younger than a certain date, because what has happened is in the last 30 years, most of the courts never forwarded the records. So a lot of people who were arrested, it was completely dropped the next day, you know, nothing happened. The records have been destroyed, okay, so literally incinerated by the courts, right? So there's a guilty until proven innocent situation. As I said, we put together a group of people affected by this. We have a lawsuit in process, and I can tell you that the AAG is not enjoying that process whatsoever.
I'll tell you where I'm coming from, Marcos. I need to continue on this, okay? Please, excuse me. I'm a credentialed teacher in the state of California. And whether I have a background or not, as long as my status is clear and current, DOJ cannot touch me. So if I put through a firearms purchase, it has to clear. If it doesn't, DOJ has to explain to the CTC what they're seeing that they're not seeing to do an investigation on. So I'm asking
one of our plaintiffs has a carry license from the DOJ and can't buy a gun. If you're thinking there's anything rational here, you're not understanding government. So what I'm trying to say is, the DOJ ran and continues to run the live scans and the background checks for carry licenses. They are clearing these people because the policy is that there's no conviction, you have to give it to them. But Kamala changed the policy for the drugs. That's why we sued. They've got no leg to stand on. It's simply a matter of time before they lose that.
But are you doing the same probing with individuals who are employees of the state or licensees of the state.
I'm saying I've got better. I've got specifically employed people who have had DOJ giving them the same credential they then turn around and say they can't have. I can get people who can't get their drugs through that do a personal firearms eligibility check and will pass. So I know exactly what's going on in the records. How do I put it? Over the years, we went from having what I would call a relatively hostile relationship with the California Department of Justice Firearms to actually having a very good working relationship with the California Justice Firearms. And we get to now hear what the policy is versus what the truth is. And so you would never see any of our lawsuits be very well tailored to attack the policy.
So have you had a case where a teacher was being put on delay without them explaining to the CTC why this happened?
Absolutely. So DOJ is not telling anyone else why they're holding firearms back, because you aren't actually a criminal.
Is there any way to actually go after any of these bureaucrats as individuals when it's obvious that they're doing these things for their own personal reason?
The question is, any way to go after them personally? We've made the laughing fool of some of them and run them out on a rail. So, for example, Allison Merrilees does not work at DOJ anymore. She's now working back on the legislative side. The answer is that you sue them in their individual capacity, but the state covers it anyway, so you don't actually touch them. In certain cases, you can hurt them a touch politically, but that's about it.
We're getting down to the wire here. Let's have like 2 more questions and then we'll wrap it up. Yeah.
So I may be out of date with this, but I thought I had seen 2 pieces of proposed legislation. One that was trying to reverse the grandfather clause for high-capacity magazines, and another one that was trying to ban the ownership of higher-capacity magazines that have been down converted to 10-rail.
So the question was, did I see legislation that was trying to retroactively remove the possession of magazines more than 10, or alter the possession of magazines that have been altered to be less than 10? You did see that. It's been amended pretty heavily. It has some potential to pass, but I'm not so sure about its actual long-term legs. It has gotten a lot less insane, because when you're correct, when it was first put in front, it was even going after 10 to 30s in the lingo. So the issue gets to be that it's almost impossible to define what they'd like to define. And as they go through more of the committee hearings, you see more and more of the actual legislative analysts make it pretty clear that you can't figure out what's actually banned in those situations. Because I don't know how much but luckily there are enough honest anti-gunners to explain that even 10-round California pistol magazines are actually often 12 or 15-round magazines with a special plastic floor plate instead, right? So those issues have made them have to simplify the bill. As I said, it's somewhat unlikely that Governor Brown would sign something that had such a mass dispossession in it, because he's worried about the Fifth Amendment issues and not just the Second Amendment issues. So.
Same for the reversing of the grandfather clause?
The reversing of the grandfather clause is, from my perspective, the only thing that has any legs left to it. In other words, I don't think you're going to see anybody effectively go after, succeed at going after limited magazines, because even the manufacturers, that's how they get to having California magazines at all. New York got into this problem where they basically banned the sale of any magazine larger than 7 rounds, and it dispossesses you of new handguns, period, because there are no 7-round magazines for most major semi-automatic firearms, right? Anything outside of 45 ACP, Glocks, SIGs, they all are 10-round, absolutely minimum. So. The search warrant be obtained on hearsay evidence. Not usually, but once in a while, weird things happen. Take one more.
Hey, Gene,
it's a question, Nikki, not a statement.
question. This upcoming Sunday, what do you think the impact of what we're going to do in San Francisco has for gun rights?
So this Sunday, some Calguns Foundation volunteers and the Pink Pistols will march in the Gay Pride Parade. It is a surprisingly useful mind bender for liberal San Francisco politics. You are all invited. It is actually a lot more fun than you would expect it to be. It is really interesting to see who actually supports statements like marriage license, carry license, and armed gays don't get bashed. And folks, I'll tell you, it's one of the most important things we do because of its politics bending. If we want to have the right to arms to be taken seriously in California for the next 50 years, we need to reach to other places so that people understand that this is a civil right. It's a civil right of everyone, and it's in everyone's best interest to have that level of self-defense. So, thank you all.
Thank you again, Gene, for coming out and spending your time here. It's very important to us. I'm going to turn it over to Mr. Mark here, who's got a gift for you.
Now, Mr. Hoffman was being cryptic when he said that Calguns was flush with cash. That's actually a problem, because you can't just have a lot of money laying around. You got to use it. So they apparently copied us. They went out and bought a vineyard. And they've now come up with Calguns Cabernet. And for some reason, they have the master vintner as Mr. Gene Hoffman. Once again, Gene, ladies and gentlemen, the man is all over the country. That he would pull out time of his schedule to come be with us today it's an honor. So, Gene, I thank you very much. Please call us if you can do that.
Thank you again, Gene. I echo Mark's sentiments there. So, one of the things that they need help with is they need funding. He says he's flush with cash, but there's never enough. Gene, did you bring receipts? You are tax deductible, correct?
Tax deductible. If you hand it to me, it'll get taken care of correctly. Okay, it is tax deductible. He will give you a receipt. I would like to make a motion with Mark's concurrence that the club match the first $250 that the members contribute. So if I could get a second on that. Second. So if we could get a vote. All in favor?
Yes. Aye.
Opposed? Okay. The motion carries.
Now,
so,
who's got the hat? We need $250.
So if you can bring your donations up here, we'll take it down and we'll get it going. That's great. We appreciate that help.